Here's a summary of the April 17th, 2025 Supreme Court opinion in the case called Monsalvo Velazquez versus Bondi, Attorney General, case number 23-929. The question presented in this case is, when a non-citizen's voluntary departure period ends on a weekend or public holiday, is a motion to reopen filed the next business day sufficient to avoid the penalties for failure to depart? Justice Gorsuch delivered the opinion of the court, in which the following justices joined: Chief Justice Roberts, Justice Sotomayor, Justice Kagan, and Justice Jackson. Justice Thomas filed a dissenting opinion, joined by Justice Alito, and joined by Justice Kavanaugh and Justice Barrett as to Part 1 and Part 2. Justice Alito and Justice Barrett filed dissenting opinions, both joined by Justice Kavanaugh. Please note that this opinion is read by an automated voice. The reporter of decisions prepared the syllabus of the majority opinion. I wrote the summaries of the dissenting opinions in a syllabus format.
Justice Gorsuch's majority opinion from the syllabus. The federal government initiated removal proceedings against petitioner Monsalvo Velazquez, who asked the government to suspend its removal efforts or, alternatively, to permit him to leave the United States voluntarily. The immigration judge concluded Monsalvo was removable, but granted him an opportunity to voluntarily depart within 60 days. After the Board of Immigration Appeals rejected his appeal, it granted Monsalvo a new 60-day voluntary departure period. The 60th day fell on Saturday, December 11, 2021. Monsalvo filed a motion to reopen proceedings on Monday, December 13th. The board rejected that motion, concluding that the voluntary departure period had expired on Saturday, and Monsalvo's motion was therefore too late. Monsalvo asked the board to reconsider that conclusion, but the board refused. Monsalvo then petitioned for judicial review in the 10th Circuit. The 10th Circuit agreed with the board, holding that the voluntary departure deadline in 8 U.S.C. Section 1229 CB2 refers to calendar days with no extension for deadlines that fall on weekends or holidays. Held 1. This court has jurisdiction to review Monsalvo's petition. Under Section 1252, courts may review final orders of removal and all questions of law arising from them. Monsalvo's petition sought judicial review of a legal question about the meaning of a term in his final removal order, specifically the meaning of 60 days for voluntary departure. Although Monsalvo did not challenge his removability, nothing in Section 1252 requires an individual to press a challenge to one term in a final order of removal just to secure judicial review of another. This court rejects the government's argument that a petition must include a challenge to removability to secure judicial review. Such an interpretation would force litigants to assert meritless claims simply to obtain jurisdiction. PP 6 do Att'y. 2. Under Section 1229 CB2, a voluntary departure deadline that falls on a weekend or legal holiday extends to the next business day. The Board and the 10th Circuit understood days to bear the ordinary meaning of calendar days, no more or less, but evidence suggests a specialized meaning in legal settings where the term days is often understood to extend deadlines falling on a weekend or legal holiday to the next business day. When Congress adopts a new law against the backdrop of a long-standing administrative construction, the court generally presumes the new provision works in harmony with what came before. Hague versus AG, 453 U.S. 280, 297 to 298. Since at least the 1950s, immigration regulations have provided that when calculating deadlines, the term day carries its specialized meaning by excluding Sundays and legal holidays, and later Saturdays, if a deadline would otherwise fall on one of those days. Congress enacted Section 1229 CB2 as part of Section 304 of the Illegal Immigration Reform and Immigrant Responsibility Act of 1996 IIIRIRA against this consistent regulatory backdrop. The government concedes that other deadlines in the same section of IRIRA, such as deadlines for motions to reopen or reconsider, are subject to this rule. The identical term days should be given the same meaning throughout Section 304, especially when the provisions were enacted at the same time in the same section of the law. Three principal counterarguments are insufficient to overcome the presumption that Section 1229 CB2 follows the government's own long-standing practice of extending deadlines falling on a weekend or legal holiday to the next business day. First, the fact that the regulatory definition of day applies directly only to regulatory deadlines and not to statutory deadlines like the one found in Section 1229 CB22 is irrelevant. The question here is not whether a regulation can trump a statute, but whether Congress's work in Section 304 of IRIRA should be read in light of the government's long-standing regulatory practice. Second, the argument that Congress intended different treatment for voluntary departure because it selected 60 days rather than adopting a pre-existing regulatory deadline of 90 or 30 days is unpersuasive, as nothing in Section 304 hints that deadlines should operate differently, and the government itself did not advance this view when promulgating rules to enforce the deadline. Third, nothing in the text supports the government's proposed distinction between procedural and substantive deadlines, as Section 304 does not draw such lines, nor does the regulatory background suggest this distinction. PP 1117, 88, F, 4th Street, 1301, reversed and remanded.
Dissenting opinions. Justice Thomas's dissent. Given the government's serious novel jurisdictional objection raised at the merits stage, the court should have vacated and remanded for the 10th Circuit's consideration rather than reaching the merits. The jurisdictional issue stems from Monsalvo's unusual litigation strategy, seeking review only of the BIA's denial of his reconsideration motion, which challenged only the timeliness determination, but not the underlying removability finding. This jurisdictional question was not raised below, has not been passed upon by any court, and warrants careful consideration, given Congress's power over federal jurisdiction as an essential element of separation of powers. Under Nasrallah versus Barr, a final order of removal refers only to the portion of a decision that finds or orders removability, not the entirety of that decision. Monsalvo's petition did not challenge either his final order of removal itself or its validity, as he sought only to clarify the meaning of the voluntary departure deadline. His attempt to characterize the BIA's warning about statutory penalties as terms of the removal order fails because those statements merely provided notice of the law's requirements rather than imposing independent obligations. Without a genuine challenge to the removal order, the 10th Circuit lacked jurisdiction under 8 U.S.C. Section 1252.
Justice Alito's dissent. The merits question regarding whether petitioner left the United States within 60 days after October 12, 2021, is straightforward. The 60th day was Saturday, December 11, 2021. 2021, and petitioner failed to depart by that date. There is no justification for extending this clear deadline by 2 days simply because it fell on a weekend, as petitioner had various means available to leave the country on or before Saturday, including driving, taking a bus, or flying to Mexico or any other country that would admit him. The court's sympathy for petitioner's circumstances cannot justify departing from the ordinary meaning of days in the statute. The regulatory definition cited by the majority applies only to deadlines in immigration regulations, not statutory deadlines. Moreover, the court's interpretation would create an unjustified disparity, giving nearly half of aliens granted voluntary departure extra time simply because their deadlines happen to fall on weekends or holidays. The term should maintain its ordinary meaning, except where there is a specific reason to adopt a specialized meaning, as with filing deadlines where compliance on weekends or holidays may be impossible.
Justice Barrett's dissent. The jurisdictional question need not turn on debating the scope of what constitutes a final order of removal, whether it encompasses an entire IJ or BIA decision, or just the removability finding. Regardless of how broadly the removal order is construed, Monsalvo did not dispute any part of it. His petition sought review only of the BIA's denial of his motion to reconsider its denial of his motion to reopen, specifically challenging only the interpretation of how to count days under Section 1229 CB2. The court's attempt to reframe a request for statutory interpretation as a challenge to the original voluntary departure order fails because seeking clarification about an order's meaning does not address its validity. Section 1252b9's zipper clause reinforces rather than undermines this conclusion, as it requires a challenge to a final order of removal that is absent here. Since Monsalvo conceded his final order of removal was lawful, the 10th Circuit lacked jurisdiction to consider his petition.
Interplay between majority and other opinions. Justice Thomas authored the primary dissent, joined in full by Justice Alito, and in parts I and II by Justices Kavanaugh and Barrett. Justice Alito wrote separately, joined by Kavanaugh, as did Justice Barrett, also joined by Kavanaugh. The dissenters united on two key points. First, that the court should have remanded for the 10th Circuit to address jurisdiction, and second, that the majority erred in finding jurisdiction. However, they diverged significantly on their reasoning for why jurisdiction was lacking. Justice Thomas's dissent focused primarily on the jurisdictional question, arguing that under Nasrallah versus Barr, a final order of removal refers only to the portion of a BIA decision that finds or orders removability, not the entire decision. Justice Barrett, while agreeing that jurisdiction was lacking, explicitly rejected this narrow interpretation debate as unnecessary to resolve the case. Her shorter dissent argued that regardless of how broadly one construes the removal order, Monsalvo did not actually dispute any part of it, making the scope question irrelevant. Justice Alito, while joining Justice Thomas's jurisdictional analysis, wrote separately to focus on the merits, arguing that 60 days means 60 days, and rejecting the majority's specialized interpretation of deadline extensions. The dissenters' varying approaches highlight their different concerns with the majority opinion. Justice Thomas worried about the court overstepping its jurisdictional bounds and departing from Nasrallah's precedent. Justice Barrett focused on what she saw as a more fundamental jurisdictional flaw, the absence of any actual challenge to the removal order. Justice Alito, while sharing these jurisdictional concerns, emphasized what he viewed as the majority's unwarranted departure from the plain meaning of statutory text. This created an unusual alignment where all dissenting justices agreed on the outcome but emphasized different aspects of the majority's perceived errors, with Kavanaugh notably joining all three dissenting opinions, suggesting agreement with each of their distinct analytical approaches.